Good afternoon.
Good afternoon.
Good afternoon.
Let's.
Go,
Your Honor, can you hear me?
Yes,
All right. You guys ready?
we are.
Actually, can you break me out with,
Sure.
thank you.
There you go.
Thank you, sir.
I can't hear anybody.
All right, better. All ready to go?
Yes, sir.
All right. Let's be on the record in case number 2020CR826, captioned State of Kansas versus Nicodemus Gunter. Would the parties announce their appearances, please?
May it please the court, Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas.
May I please record the defendant appears in person via Zoom and through counsel Jeffrey Liker, also via Zoom.
All right, we are here set down for a sentencing today. I would note for the record that the parties were last in court again by Zoom back on April 12th, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, and set it for sentencing today. I've received that PSI. The critical findings are as follows. The sole count of conviction is one of violation of the Offender Registration Act, which is a severity level 5 person felony. The defendant's criminal history score is found to be that of A as in Adam. That would make him presumptively prison with a presumed underlying range of 122, 130, or 136 months. If he has to do that time, he'll be eligible for up to 15% good time credit and subject to 24 months of post-release supervision. Special rules number 9 and 46, which are that the crime was committed while on probation and it is a violation of the Offender Registration Act, apply. If he were to be granted probation today, it would be for a period of 36 months to community corrections. I'll ask you first, Mr. Schneider, did you have an opportunity to review the PSI? Do you have any additions, corrections, or challenges to those findings?
No, Your Honor.
Mr. Liker?
No, Your Honor, it came back as expected.
All right. Mr. Liker, you filed a motion for a downward departure. Would you like to be heard on that this afternoon?
Very briefly, Judge.
Sure.
As I stated, this PSI came back exactly the way that we expected it. And if you look at it, the only thing that's on there is the underlying offense that he was convicted of or adjudicated of, at least as a juvenile. It's a little bit of a sadder case, Judge. This was a situation where he was convicted of that when he was in the foster care system here in the state of Kansas. Since he was released from that system, he's pretty much, for the most part, been homeless. And so this is not the first time that he's run into trouble with this offender registration, but the truth of the matter, he's never really had a place to register from, of any permanence, certainly. And so he obviously understands what the law is in this case, and I think the court is a little bit hamstrung by the way the law is situated in this case, but this does appear to be a pretty unique set of circumstances. Gentleman leads a pretty unique lifestyle in that he just has really never had any permanence since he was in the Kansas foster care system. And so we have negotiated this after a couple of days, sessions of negotiations, and I think the state is okay with the court accepting the agreement as we filed here, and I would ask the court to adopt that as its final order in this case.
All right. Mr. Schneider, I will hear your comments as to defendant's motion and anything else touching upon sentencing.
Judge, Mr. Liker's statements to the court, I think were totally accurate. This is kind of a sad case in that the defendant was in the foster care system, and this court spent plenty of time handling those kinds of cases. So I have no doubt the court is aware of the pitfalls of the foster care system and the system, particularly once folks age out of that system. Judge, that's a big reason why we agreed as part of the plea agreement to recommend the durational departure to the court, because the presumptive terms of sentences of over 10 years seem rather onerous and certainly not just given the defendant's background. So I would ask the court to follow the plea agreement and impose the 48-month sentence.
All right, thank you. Mr. Gunter, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I don't have anything that I want to say.
All right. Mr. Liker, do you know any legal reason why I should not now proceed to sentencing?
I do not, Judge.
All right. I'm going to follow the plea agreement. I'm going to find there are substantial and compelling reasons to depart from the sentencing guidelines, and I will adopt as those reasons, those set out in defendant's motion and with defense counsel, as well as prosecutor's comments today. Therefore, the defendant will be sentenced to a period in the Department of Corrections of 48 months. He's not applying for probation. Probation is not appropriate in this case, and it will be denied. He will be subject to 24 months of post-release supervision upon his release. He's entitled to 15% good time credit, or up to 15% good time credit, and credit for all of the time that he has spent in custody up until this time. My intent, given the defendant's history and lack of resources, I'm going to waive the court costs. I'm going to waive attorney's fees. There is no supervision fee as he's not being placed on supervision. His DNA is already in the database, so there's no need for that. So that will leave him with zero costs and fees. All right.
Judge.
Mr. Gunter, you have 14 days from today to appeal anything you do not like about your sentence, and you may be able to seek expungement after a period of time following successful completion of post-release supervision. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that?
Yes, Your Honor.
All right. Look, Mr. Gunter, I hate the fact that, and Mr. Liker's right, that court's hands are pretty tied in this matter. And I have no problem cutting, what amounts to about 6-7 years off the sentence there. But, and look, the good thing, I suppose, is you've been in there for a while now, and you're going to get credit for that, and 15% off your sentence. I really need you to make a plan when you get out how you're going to be able to register, because if you can't do that, then this is just going to come up, and each time it comes up, it's going to be harder and harder for a court to give you a break, okay? And I understand your unique circumstances, and I think you certainly should, when you get out, get a court to waive the costs if you don't have any resources, so that you don't have to pay to register. But you need to be able to find your way up to the office to register when you get out, so that this doesn't keep happening to you, okay?
Okay.
All right. Mr. Schneider, anything that I failed to cover today?
Judge, does the sentence in this case run consecutive to that in 2015 CR 922?
I'm not.
Gave rise to the special rule.
Yeah, I don't recall. I thought we were deciding to close that case unsuccessfully as part of
That's
this
correct.
plea.
That's
Yeah.
correct. That case was closed.
Right.
Okay.
Yeah, that's what I thought. Okay. Anything else, Chris?
No, Your Honor. Only Mr. Liker will probably on Monday send you the journal entry for your review and electronic signature.
I'll be here.
All right.
All right. Anything else for our record, Mr. Liker?
No, sir. Thank you.
All right, Nicodemus, good luck to you, buddy. I hope the best for you, okay?
Okay. Thank you so much.
Thank you. We are adjourned.
Thank you,
Thank you,
Judge.
Judge.
Thank you. Everyone have a good weekend.